said that rather Kenyans always open the book of Lamentations, year in, year out. We open the books of Lamentation, but today let us open the book of Revelation as well. Eh? Let's open it up. Like Justice had alluded earlier, when it comes to the oversight or accountability in the judiciary, we find that judicial officers who found themselves pretty much at the dock are being asked to answer to questions have run to court to stop the JSC from investigating them and coming up with a decision thereafter. Many ask the question then, is the judiciary itself being used to fight accountability?
Mm-hmm. Okay. First of all, let me apologize. I normally don't like to come late.
Apology accepted.
But today it happened. Mm-hmm. And I'm really honored to be present with my senior. Mm-hmm. We worked together at School of Law, University of Nairobi, and he was ahead of me. And actually, among the very many things that he did, including the radical surgery,
slaying the dragon.
Yes. He actually facilitated the referendum that the people must speak on the Katiba. They must, decide. It can't just be done by Parliament. And that was a major decision brought about by Reverend Dr. Njoya, among others. I think the judiciary, and I actually, when I worked as a governor, the judiciary helped tremendously to safeguard devolution, because there were times when the executive wanted to do things that would erode the functions of the devolved government, Schedule 4 functions, and there was a lot of protection from the judiciary. But I think one of the problems that has arisen is the judiciary, particularly the apex courts, saying that if anybody wants to proceed against them, it can only be through the constitutional removal procedures, so that there isn't an intermediate way of trying to hold the judges accountable for matters that may not necessarily be what is anticipated under the Constitution, where there is removal by making sure that there is panels appointed and so on. So I think in terms of resisting a process of actually looking at some of the lesser issues, so to speak, then the judiciary has made itself vulnerable. And that is why I would imagine the lawyers, have come out saying that during their practice, they are finding that some judges, not all judges, but some judges, maybe, in the magistracy also, and so on, they are finding that it's not easy to practice the law because some of them are not very accountable. But also, it takes two to tango, because also some of the lawyers themselves are also culprits. Not only the lawyers, but some of the citizens themselves think that you can fix a case, you can also bribe, judges, magistrates, and so on and so forth. And therefore, I think it's not enough to simply say that if accountability questions are being asked, then you try to block such accountability questions by going to court, and if it is a judge who is being processed, or there's a desire to process them, you go to court to another judge, and so there can be conflict of interest. So I think this matter requires a lot of deliberations, because when citizens think that judges are playing safe, so that when one judge has issues, another judge protects the one with issues. So that will not look good. But at the same time, we also have to be careful so that we don't get another branch of government wanting to also destroy the judiciary, so to speak. So, as my senior said, the judiciary is like a line of last defense. So if that line is eroded, then and sometimes Parliament itself is not very robust. Sometimes it's said it's compromised. So it means that actually institutions can be eroded to the extent that the citizens don't have some institutions to rely on to protect, their rights to protect